then address the Court on the construction of Articles 9 and 1 of the Genocide Convention. Cyprus has exercised its right to intervene in this case under Article 63 of the Statute of the Court for two reasons. First, Cyprus wishes to put forward its views on the interpretation of the compromissory clause of the Convention of a great importance, whose construction is evidently in question in the present stage of the proceedings. This is not only because of the steadfast devotion of Cyprus to the peaceful settlement of international disputes. It is also because, as these proceedings make clear, the construction of the compromise necessarily brings into the frame the interpretation of other provisions of the Convention and of relevant rules of international law. These provisions and rules are, to quote from the Court's order of 5 June 2023, relevant to determining jurisdiction ratione materiae in this case, and are thus in question in the preliminary objections stage. Second, Cyprus speaks on a matter that is existential for it. Being a small state, with its own experience as a victim of unlawful invasion and occupation, Cyprus heavily relies for its security on the international legal order, with the Charter of the United Nations at its core. It is thus crucial for Cyprus that provisions in treaties are not left to the own appraisal of any state party in order to justify the use of force against other states, but are properly construed by states and ultimately by this Court. The construction of Article 9 of the Convention will allow the Court to consider whether reliance on the Convention can ever serve as a lawful basis for recourse to armed force. The submissions of Cyprus focus solely on the construction of the Convention without assuming or discussing any purported facts. Cyprus has thus limited itself throughout the written and these oral proceedings to making observations on the construction of the Convention without taking a position on any other matter before the Court in this case. Madam President, I would now ask you to call Mr. Giannakopoulos to the podium. I thank the Court for its attention.
I thank Ms. Stavronidis, and I now invite the second speaker for Cyprus, Professor Antonios Giannakopoulos, to address the Court. You have the floor, Professor.
Madam President, members of the Court, it is an honor to appear before you today on behalf of the Republic of Cyprus. Cyprus makes two submissions on the construction of Articles 9 and 1 of the Convention. First, the scope of Article 9 encompasses disputes over whether the Convention has been invoked and over whether facts that call the Convention into application have taken place. It has been set out in written argument, as well as in the oral proceedings thus far, that the compromissory clause of the Convention is expressed in broad terms. Cyprus did not revisit the arguments on the broad scope of Article 9 right now. I will rather use an example to approach the question of scope, referring explicitly to the terms of Article 9. Now, if one state party asserts that another state party is violating the Convention, and the two states disagree on this, the former state party can evidently bring a claim before the Court on the basis of Article 9. If this is accepted, then it must also be that the latter state party, that is, the one accused of violating the Convention and positively opposing this accusation, may avail itself of the very same right. A state party must be able to request the Court to determine that any accusations of violation of the Convention levelled against it are ill-founded. In other words, it must be afforded the opportunity to clear its name. Article 9 provides it exactly with that opportunity. The relevant dispute is thus clearly one that relates to the responsibility of a state for genocide. This must be so, especially when an allegation of genocide is relied upon to resort to armed force. In such cases, a state party cannot hide behind the vagueness of its claims relating to the invocation of the Convention or the reliance upon the Convention in order to avoid having its allegations tested before the court. If the compromissory clause could not be invoked to bring such matters to the court, its effectiveness would be severely curtailed. Second, Cyprus submits that Article 9 of the Convention encompasses disputes as to the proper scope of the obligations to prevent and punish genocide under Article 1. An allegation that genocide is taking place activates the obligations of states parties to the Convention to prevent and punish the crime of genocide in accordance with its Article 1. Cyprus submits that the action taken by a state party in purported performance of its obligations to prevent genocide must be able to be tested. And it must be tested against the requirements of the Convention regarding the obligation, and thus also the outer limits of the right of a state party to prevent genocide. To put it simply, much like in alleging genocide, when taking unilateral action to purportedly prevent it, a state party appraises its own legal position and acts at its own risk. This means that it may be challenged as to its own appraisal and the unilateral action that it chooses to take, and thus runs the risk of being found to have misinterpreted the Convention and to have misapplied it to the alleged facts. If one state party claims to be acting to prevent genocide and the other state party considers this action to be unlawful, then this is clearly a dispute relating to interpretation, application, or fulfillment of the Convention. The Court has subject matter jurisdiction over such a dispute under Article 9, which effectively brings to bear the risk assumed by the state party acting unilaterally. Now, what the obligation of prevention entails is crucial. In particular, the Court has already determined that in acting under Article 1, a state may only act within the limits permitted by international law, as we have heard many times over the last 3 days. In line with this finding, Cyprus submits that no action taken in response to either a real or a perceived breach of a treaty could ever lawfully involve the use of armed force in violation of Article 2, Paragraph 4 of the United Nations Charter. This is true also for determining the scope of the obligation to prevent genocide under Article 1 of the Convention. Madam President, this concludes the submission on behalf of the Republic of Cyprus. I would like to thank the Court for its attention.
I thank Professor Tsanakopoulos, and I now invite Professor Santiago Ripoll-Correa to address the Court on behalf of Spain. You have the floor, Professor.
Madam President, distinguished members of the Court, it is a great honor to appear before you as agent of the Kingdom of Spain. Spain, among other 31 states, submitted a declaration of intervention under Article 63, Paragraph 2 of the Statute of the International Court of Justice. As determined by the Court in Paragraph 69 of its Order on Admissibility of the Declarations of Intervention adopted in June 2023, the construction of Article 9 and of other provisions of the Genocide Convention concerning the Court's jurisdiction ratione materiae is in question at the present stage of the proceedings. Spain wishes to offer the Court its interpretation of Article 9, considering that its statement may be of help for the construction of this article, and aware that this intervention implies that Spain will be bound by the Court's decision. Distinguished members of the Court, Article 9 of the Convention on the Prevention and Punishment of the Crime of Genocide confers jurisdiction to the Court to hear any dispute concerning the interpretation, application, or fulfilment of any provision of the Convention. Whereas the terms interpretation and application are terms commonly included in many compromissory clauses, the term fulfilment is unique as compared with the compromissory clauses found in other multilateral treaties. Indeed, during the drafting process of the Genocide Convention, there was a debate on the inclusion or not of the term fulfilment, which ended with its retention in the text finally adopted. Consequently, Spain considered that the term fulfilment should be interpreted as an autonomous reference to one of the three categories of disputes between states parties that may be submitted to the Court under Article 9, that is, in a manner similar to disputes concerning the interpretation or application of the Convention. Let me, Madam President, elaborate on this idea in a little more detail. A state party to the Genocide Convention assume some specific duties to prevent and prosecute the crime of genocide at the national level. They are obliged not only not to commit genocide, but also to take measures to prevent and punish the crime of genocide, including the enactment of relevant legislation and punishing the perpetrators. Additionally, based on the assessment that genocide is a crime under international law, the Convention also encourages states to fight against genocide at the international level. Indeed, as the Court has stated, the contracting parties to the Convention must prevent and punish any act of genocide independently of the context of war or of peace in which it takes place, and independently of the circumstances linked to the domestic or international nature of the conflict. Moreover, this obligation is not territorially limited by the Convention. In this sense, in its judgment of February 2007 on the application of the Genocide Convention, the Court has referred to the obligation to prevent genocide even by states distant from the place of the event. As Spain has argued in its written text, it follows that the adoption of all these measures to prevent and punish the crime of genocide, both at the national and international levels, and with a scope as broad as the one described above, all these measures should be included under the concept of fulfilment. Therefore, in Spain's view, the inclusion of the term fulfilment entitles states parties to the Genocide Convention to submit to the Court a dispute that relates to any measure or action taken by another state party, including any form of measure or action clearly contrary to Article 1 and to the object and purpose of the Convention. Madam President, this interpretation of the term fulfilment is, as Spain has demonstrated in its written observation, is consistent with the interpretation given to it in international human rights law, of which the Genocide Convention is one of its most prominent precedents, as the Court pointed out in 1951. It is clear, moreover, that in adopting measures to prevent genocide, a state must act in accordance with the principles of international law as formulated in the Charter of the United Nations and in General Assembly Resolution 2625, including the principles of good faith, prohibition of the use of force, and non-intervention in internal affairs. Thus, the adoption of preventive measures that exceed the limits permitted by international law can also constitute a violation of the obligation to prevent as stated by the Convention, especially if such measures involve an abuse of law or have been taken contrary to the principle of good faith. Distinguished members of the Court, according to the interpretation of Article 9, and in particular of the term fulfilment offered by Spain, it is possible for a state party to submit to the Court any dispute regarding measures, actions or omissions adopted by another state party supposed to prevent a situation qualified by the latter as genocide, but which nevertheless constitute measures, actions or omissions that turn to be contrary to the object and purpose of the Convention because of the manner in which they are carried out, or the lack of good faith, or because of the manifest abuse. Whether or not these acts or omissions are contrary to the object and purpose of the Convention, whether or not they are taken in bad faith, or whether or not the recourse to the Convention is abusive, is to be determined by the Court. Madam President, distinguished members of the Court, Spain considers that this interpretation of Article 9 is consistent with the ultimate objective of the Convention, which, as stated in its preamble, is none other than to liberate humanity from genocide, a crime under international law contrary to the spirit and aims of the United Nations and condemned by the civilized world. Spain thanks the Court for your attention.
I thank Professor Ripoll Correa, and I now give the floor to His Excellency Mr. François Alabrun for France. You have the floor, Excellency.
Madam President, distinguished members of the Court, it's a great honor for me to represent as co-agent my country before the Court. Just like 31 other states parties to the 1948 Convention for the Prevention and Punishment of the Crime of Genocide, France deemed it necessary to avail itself of its right to intervene in this case on the basis of Article 63 of the Statute of the Court. And in this respect, France wishes to emphasize the efforts of close coordination made by all member states of the European Union participating in the current proceedings in order to facilitate the Court's work. Madam President, members of the Court, I will focus on 2 points. I will first indicate that the Court has the right to focus on different cases, a large variety of disputes related to the Convention. And secondly, I will come back to the relevance of general international law for the construction of the 1948 Convention, and more specifically Article 9. As to the question of the construction of Article 9, which arises at the jurisdiction state, it allows you to determine which dispute categories are likely to be submitted to the Court. However, as many intervening states have already underscored, the wording of Article 9 is one of a kind. It includes many specificities which have the effect of broadening its scope compared to other compromissory clauses. In accordance with the rules of construction as codified in the 1969 Vienna Convention, the terms used in Article 9 of the Genocide Convention must be interpreted so as to determine its exact scope. And I will make two brief observations in this regard. First of all, the terms of Article 9 do not involve any restriction on the configuration of the dispute. The Court may be seized by any contracting party in order to establish a breach by the respondent of its international obligations, or, as the case may be, a non-violation by the applicant of its obligations. Secondly, The court can hear disputes related not just to the interpretation application, but also to the fulfillment of the Genocide Convention. And my country's opinion is that this is an important indication that the scope covered by Article 9 of the Convention should not be interpreted too restrictively. I would now like to make some observations on the connection between the 1948 Convention and international law and the consequences of this connection when interpreting Article 9. And in this regard, France deems it necessary to react to some of the interpretations of Article 9 suggested in these proceedings. I will come back in particular to the hazardous parallel drawn between the present case and the immunities and criminal proceedings case a few years ago between Equatorial Guinea and France, and that led to a judgment on preliminary objections on 6th of June 2018. In that case, the applicant had offered a broad interpretation of Article 4 of the Palermo Convention against transnational organized crime in an attempt to artificially extend the scope of the consent given under this instrument. Article 4, paragraph 1 states that state parties shall carry out their obligations under this convention in a manner consistent with the principles of sovereign equality and territorial integrity of states and that of non-intervention in the domestic affairs of other states. End of quotation. And the applicant had deduced the following from this article, and I quote, the customary international rules on immunities of states and state officials and on the immunity of state property from execution are incorporated into Article 4, and the court did not admit such a reading, and on the contrary held that Article 4 only refers to general principles of international law and that the rules of customary international law relating to immunities of states and their agents are not incorporated in Article 4. But we cannot rely on this case to support the interpretation, which is overly restrictive, of the 1948 Convention, because the legal issues are resolutely distinct. And in this regard, I shall make two brief remarks. First, Article 4 of the Palermo Convention is a general clause at the beginning of this convention, whose purpose is to recall the principle of sovereignty and not to establish new obligations under the convention. On the other hand, Article 9 of the 1948 Convention is a compromissory clause unique to this convention and relates to the settlement of disputes on treaty obligations. We know that compromissory clauses have a very specific aim, which is to confer jurisdiction to a judicial organ. They are procedural provisions, not substantive provisions, which function by reference. That is to say, they do not in themselves determine which is the applicable law for the settlement of disputes regarding the Convention, but they refer to the rest of the Convention to determine that law. These clauses, they will have their own logic, which must be taken into account when interpreting them. Secondly, in the immunities and criminal proceedings case, the court recalled that a provision of a convention could not be interpreted in a way that integrates rules that were completely foreign to that convention. In so doing, the court has never held that the abusive interpretation and fulfillment of one of the provisions of the convention for purposes manifestly contrary to its objects and principles would fall outside the scope of that convention. Paradoxically, such a solution would in fact remove the most serious disputes on manifestly abusive interpretation and fulfillment of the treaty from the scope covered by the compromissory clause. Again, in this case, the court has no way indicated that the dispute in the way in which the convention is to be fulfilled did not concern the application and interpretation of this convention. On the contrary, although that was not the subject matter of the present case, it accepted that, and I quote, any interpretation which might arise with regard to the interpretation and application of Article 4 of the Palermo Convention could relate only to the manner in which the states parties perform their obligation under the Convention. End of quote. In this case, it is indeed the obligations contained in the Convention that are at issue, and the dispute concerns the manner in which they are fulfilled. In this respect, as the Court explained, state parties may be expected to perform their treaty obligations in a certain way without the text actually providing for specific obligations. This is the case, for example, of the obligation to fulfill treaties in good faith. Admittedly, the 1948 Convention does not contain a provision as such expressly prohibiting it from being fulfilled unreasonably in relation to its object or purpose. However, this does not mean that a state is permitted to do so, because fulfillment in good faith necessarily follows from any treaty obligation. In France's opinion, it follows that disputes resulting from abusive allegations of genocide or relating to abusive instrumentalization of the obligation to prevent and punish genocide fall within the scope of the provisions of the Genocide Convention and therefore fall within the scope of consent provided by Article 9. Madam President, members of the Court, thank you for your kind attention.
I thank His Excellency Mr. Alibrun, and I now invite Ms. Zonovia Chaido-Stavridis to address the Court.
I now give the floor
Madam President, distinguished members of the Court, it is a great honour and privilege for me to appear before this Court today on behalf of my country. It should be stressed that as a matter of principle, the Hellenic Republic attaches the utmost importance to the peaceful settlement of international disputes, in particular through the International Court of Justice. The Hellenic Republic, as a party to the Genocide Convention, a major treaty seeking to condemn and punish a crime which shocks the conscience of mankind, appears here today because of its interest in ensuring the Convention's proper interpretation and, by extension, application and fulfilment. Consistent with our declaration of intervention and our written observations, I will focus on what we believe to be the proper construction of Article 9 of the Genocide Convention. This construction converges with that put forward by other intervening EU member states. Our interpretation of Article 9 is based on Article 31 of the 1969 Vienna Convention on the Law of the Treaties, reflecting customary international law. In line with paragraph 1 of this article, I will show that the ordinary meaning of Article 9, read in its context and in the light of the object and purpose of the Convention, calls for its broad interpretation and brings within the scope of this Court's jurisdiction the widest possible range of disputes arising under the Convention. I will start with the ordinary meaning of Article 9. I will not dwell upon the notion of dispute. Suffice it to say that the Hellenic Republic concurs with the interpretation given by the Court, inter alia in the present case, in its order of 16 March 2022. Regarding the phrase relating to the interpretation, application or fulfilment of the present Convention, including those relating to the responsibility of a state for genocide, the Hellenic Republic contends that Article 9 allows the Court to adjudicate upon a dispute concerning the alleged fulfilment by a contracting party of its obligations under the Convention. For the purposes of this presentation, I will divide the text of this phrase in three parts. First part, the words relating to. Second part, the phrase interpretation, application or fulfilment of the present Convention. And third part, the phrase including those relating to the responsibility of a state for genocide. In the first part, the words relating to require only that the subject matter of the dispute concerns any alleged violations of the Convention. Hence, where, like in the present case, an application concerns the conformity of certain acts with the Convention, the Court can exercise its jurisdiction under Article 9, irrespective of the question whether or not the conduct in question simultaneously breaches other rules of international law and whether or not the Court has jurisdiction over those matters. In the second part, which reads interpretation, application or fulfilment of the present Convention, the addition of the word fulfilment to the more common formulation usually found in compromissory clauses confers an added breadth to the clause, as confirmed by the travaux préparatoires, and further supports the view that the Court has jurisdiction ratione materia to declare the absence of genocide when genocide is being alleged to take place. Furthermore, the words of the Convention make clear that the compromissory clause refers back to all the provisions of the Convention, its entire life, including breaches thereof. Thus, while there can be a dispute under Article 9 when one state alleges that another state has committed genocide, there can also be a dispute under the court's jurisdiction over the question whether genocidal acts have not been committed. The third part, the phrase including those relating to responsibility of a state for genocide, further corroborates the comprehensive nature of Article 9 and its broader scope compared to a standard compromissory clause. Furthermore, the context of the words relating to in this phrase confirms that the court jurisdiction also covers disputes between states about the absence of genocide and about the performance of treaty obligations by one or more states parties. I will now discuss the last part of Article 9, namely the phrase at the request of any of the parties to the dispute. This phrase expressly provides for the jurisdiction of the court at the request of either the state that has made the accusation or the state accused. Thus, where there is a dispute concerning whether a state has engaged in conduct contrary to the Convention, the state accused of such conduct has the same right to submit the dispute to the court as a state that has made the accusation. Otherwise, a state party could freely invent violations of the Convention allegedly committed by another state party without the latter being able to have recourse to the court. This would exclude from the court's jurisdiction genocide-related disputes, leading potentially to serious misuses of the Convention. In addition, the absence in Article 9 of any of the usual procedural requirements, such as to first attempt negotiation or arbitration, corroborates the broad character of this article. Madam President, distinguished members of the Court, I will now turn to the object and purpose of the Convention, which, as eloquently described by this Court, further advocates for a wide interpretation of Article 9. I will not quote here the relevant excerpts of this Court's judgments. I should only stress that the erga omnes partes character underpinning the Convention is associated with a mission entrusted to the Court back in 1948 to enforce it in the interest of all states, and speaks against an interpretation which would preclude a state against which false allegations of genocide have been made from seeking relief from the Court in the face of abuses of the Convention. The Convention's object to protect the most elementary principles of morality also requires from the state party not to abuse its provisions to pursue other aims. The purpose of the Convention clearly allows a state party which believes that the authority of the Convention has been abused by another state party to turn to this Court. Otherwise, the raison d'etre of the Convention and its credibility as a universal instrument for the prevention of genocide would be defeated, and the role of the Court as critical avenue for redress would be undermined. Madam President, distinguished members of the Court, in conclusion, my country strongly believes that Article 9 encompasses any dispute relating to the interpretation, application or fulfilment of the Genocide Convention, including a dispute regarding acts carried out by one state party against another state party, based on abusive claims of genocide, resulting in the violation of a good faith performance of the Convention. I thank you for your attention.
I thank Ms. Stavridis. I now give the floor to Mr. Stefano Zanini for Italy. You have the floor, sir.
Madam President, distinguished members of the Court, it is an honor to address you as the agent of the Italian Republic. After my opening remarks, Professor Attila Tanzi will address few of the arguments advanced by Italy in its written pleadings, which pertain to the Court's jurisdiction ratione materie. Ever since becoming a party to the Genocide Convention in 1952, Italy has committed fully to its promotion in all relevant fora. Italy is therefore particularly pleased to seize the opportunity to assist this Court in the interpretation of the provisions which are disputed in the present case. The erga omnes nature of the core obligations of the Convention accounts for the general and indivisible interest of all contracting parties in their proper interpretation, application and fulfillment. Accordingly, Italy believes that when the interpretation of this kind of obligations is at stake and the Court is seized of the matter, the Court should exercise its jurisdiction to the fullest extent. In so doing, as the principal judicial organ of the United Nations, the Court can discharge its role of guardian of international legality in a domain where objectivity and third-party assessment are of the essence. Madam President, I thank you for your attention, and I kindly request that you invite Professor Tanzi to the podium.
I thank Professor Zanini. I now invite the second speaker for Italy, Professor Attila Tanzi, to address the Court. You have the floor, Professor.
Thank you, Madam President. Madam President, distinguished members of the Court, it is an honor to be appearing before you today and to do so on behalf of Italy in so highly important proceedings. In the interest of time, I shall confine myself to two issues of construction of the broad compromissory clause in Article 9, which bear on the Court's jurisdiction ratione materia. The first one concerns the peculiar nature of an aspect of the applicant's cause of action, which qualifies as a non-violation claim. The second pertains to the contour of the law, which the Court has the power to interpret and apply to the facts in dispute. Madam President, as to the first point, the Court's jurisprudence shows that its jurisdiction encompasses disputes submitted by states requesting a finding of compliance when compliance has been disputed by the defendant. The fact that in such cases the defendant had not challenged the admissibility of non-violation claims is irrelevant, since the Court could have raised it motu proprio under the competence principle. This general proposition applies all the more to applications grounded in Article 9, whereby the jurisdiction of the Court may be set in motion, and I quote, at the request of any of the parties to the dispute, unquote. This construction is corroborated by the interpretive principle of the effet utile, and it cannot be derogated from by a retrogressive interpretation of the travaux of the Convention. It is thus wrong to construe Article 9 as conferring jurisdiction exclusively over applications complaining of violations allegedly committed by the defendant. Madam President, members of the Court, the prohibition on genocide and its ancillary obligations of prevention and punishment reflect a peremptory norm of international law. Therefore, the applicant has a compelling interest in the ascertainment of a situation of non-violation of the Convention, as do each and all contracting parties, as well as the international community as a whole. Italy believes that it is considerations of this kind which account for the wide scope of the compromissory clause in Article 9. Madam President, members of the Court, as to my second point, I wish to stress that Italy finds that the material scope of application of the Convention covers precisely the kind of situations which are disputed in the instant case, and this fully conforms with the prima facie assertment of your Court. And nothing in the present incidental proceedings justifies reversing the authoritative statement by a former President of the Court, whereby, for the purposes of jurisdiction, the facts as alleged by the applicant are pro term to be accepted as true. Further ascertainment will be for the merits. Consequently, Article 9 confers jurisdiction on the Court to interpret and apply Articles 1 to 4 in relation to the disputed facts before you. Articles 1 and 4 provide for the obligation to prevent and punish acts of genocide, and this implies a fortiori an outright prohibition of genocidal conduct. This supports the contention that Article 9 confers jurisdiction on the Court over the defendant's allegations concerning the applicant's alleged breach of Articles 1 and 4, and all the more so over allegations of genocide tout court. By the same token, Article 9 also affords jurisdiction over the applicant's claim that the defendant's allegations amount to an abusive interpretation of Articles 1 and 4. If assessed, such an abusive interpretation would be plainly in contravention with the general principle of good faith in treaty interpretation under Article 31, paragraph 1 of the Vienna Convention on the Law of Treaties. And this would amount, at the same time, also to a breach of the very Articles 1 and 4. Madam President, Italy deems that Article 9 plainly confers jurisdiction also over the applicant's complaint concerning the defendant's act of aggression against it. The jurisdictional link between such complaint and the Convention is twofold. First, it derives from the argument that the ostensible breach of Article 1 by the applicant would preclude the wrongfulness of the defendant's aggression. Second, the defendant's act of aggression brings the interpretation of Article 4 into play in relation to the scope of the admissible measures against alleged breaches of the Convention. To that end, Article 4, which provides exclusively for criminal law measures against individuals, cannot be interpreted in isolation from the basic principles of the United Nations Charter, as confirmed by your Court. In conclusion, Madam President, Italy finds that Article 9 empowers the Court to interpret and apply Articles 1 to 4 to all the facts in dispute, and to do so in conformity with Article 31, paragraphs 1 and 3, letter C of the Vienna Convention on the Law of Treaties. Madam President, distinguished members of the Court, this concludes my speech, and I thank you for your attention.
I thank Professor Tanzi. I now invite Professor Martin Paparinskis to address the Court on behalf of Latvia. You have the floor, Professor.
Madam President, members of the Court, good afternoon. It is an honor for me to appear before you on behalf of the Republic of Latvia, in the first case in which Latvia has chosen to take part in the oral proceedings, either before the Court or its predecessor. I do so with gratitude to Latvia's agent, Ms. Kristīna Līce, for her exemplary leadership, and in the presence of Latvia's co-agent, Mr. Edgars Trumkalns. Latvia's intervention in this case reflects the importance that Latvia attributes to the integrity of the Convention on the Prevention and Punishment of the Crime of Genocide, and therefore its proper construction in this case. I will first make one general overarching point. Latvia considers that the conclusions on construction of Article 9 and of other provisions of the Genocide Convention concerning the court jurisdiction ratione materiae reached in the order of 16th of March 2022 on a prima facie basis and in terms of plausibility of rights claimed are, upon full and considered reflection, correct, and should also be adopted at the present stage of the proceedings. I will now proceed to three particular submissions on the construction on the Genocide Convention. I will first address the broad formulation of Article 9. In this respect, Latvia asks the Court to follow the construction adopted in paragraphs 168 and 169 of the judgment in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide between Bosnia and Herzegovina and Serbia and Montenegro. It would similarly go with the established judicial grain for Article 9 to cover disputes concerning what Russia calls reverse compliance complaints. That is not something alien to international law, as Russia suggested on Monday, but what the court did in rights of nationals of the United States of America and Morocco, and questions of interpretation and application of the 1971 Montreal Convention arising from the aerial incident at Lockerbie. Russia's attempts to distinguish these judgments must fail, since it cannot be the case that the court has thrice misapplied the well-established jurisprudence requiring it to go into the matter proprio motu to always be satisfied that it has jurisdiction. Nor is there anything in the hypotheticals that trouble Russia about such claims that could not be resolved by good administration of justice by the court, including on time limits, as well as by the proper application of the general principle of res judicata. I turn now to Latvia's second submission, namely that Article 9 applies to disputes concerning the prohibition of abusive allegations of genocide. Latvia agrees that Article 1 does not specify the kinds of measures that a contracting party may take to fulfill the obligation to prevent and to punish the crime of genocide. However, Latvia's submission is that when interpreted in good faith, in the context of Articles 4, 6, 7, 8, and 9, and in the light of the object and purpose of the Genocide Convention, Article 1 does prohibit allegations of genocide that are abusive. Article 9, therefore, encompasses disputes about abusive allegations of genocide, where a contracting party making them and acting upon them has neither pursued any of the means in the Genocide Convention, nor provided, in the words of the court, proof at the high level of certainty appropriate to the seriousness of the allegation. We say, in short, that we substantially agree with Professor Tuvenan. I will conclude with Latvia's third submission, namely that Article 9 applies to disputes under Articles 1 and 4 about whether a state has acted within the limits permitted by international law in preventing the commission of genocide. We say, again, that we substantially agree with Professor Tuvenan. This construction builds on the point made by the court that in discharging its duty to prevent genocide under Article 1 of the Genocide Convention, every state may only act within the limits permitted by international law. This also applies to the limits set by the applicable rules on the use of force. Latvia's submission is that Articles 1 and 4 preclude those means for prevention of genocide which are not in conformity with the spirit and aims of the United Nations highlighted in the first preamble recital of the Convention, in particular the Charter's first purpose of the suppression of acts of aggression. Further, Article 1 characterizes genocide as a crime under international law. Good faith construction of this ordinary meaning confirms impermissibility of aggression, called the supreme international crime by the International Military Tribunal just 2 years before the Convention's adoption, as a means for prevention of genocide. Professor Tuvenen must be right. The Convention, to quote him, ne peut pas être un outil permettant de justifier des crimes de droits de gens et la prolifération des fleurs les plus odieux. Latvia's submission is not undermined by judgments in cases concerning preliminary objections in oil platforms, immunities and criminal proceedings, and certain Iranian assets, which Russia invoked as authorities for rejecting rules outside the treaty for the purposes of interpretation. Reliance on oil platforms is a category error, since Article 1 of the Treaty of Amity imposed no obligation, but merely formulated a general aim. As for the latter two cases, the key point is that those rules were, in the words of the court, respectively unrelated to the stated object and purpose, and simply not germane to the concerns underlying the drafting of the treaties being interpreted. Specialized treaties on cooperation in economic and criminal matters, on the one hand, and the customary corpus on state immunity, on the other, may indeed inhabit distinct juridical spheres. The concerns, institutions, and teleology of the Genocide Convention and the rules on the use of force expressed in the United Nations Charter are, conversely, closely intertwined. Latvia's proposed construction would not, as Russia argued on Monday, incorporate in the Convention all obligations of states arising from other sources of international law, but only take into account in the process of interpretation the relevant rules mandated by the custom reflecting Article 31, paragraph 3c of the Vienna Convention on the Law of Treaties. To paraphrase the merits judgment in oil platforms, the court jurisdiction under Article 9 to interpret Articles 1 and 4 extends, where appropriate, to the determination of whether action alleged to be taken as a means for prevention and punishment of genocide was within the limits of international law, including law on the use of force. Madam President, members of the court, this concludes the submissions of Latvia at the present stage of the proceedings. I thank you for your kind attention.
I thank Professor Paperinskis. Your statement brings to an end this morning's session. The court will meet again this afternoon at 3 p.m. to hear the remainder of the oral observations of the intervening states. The sitting is adjourned.